Hello and welcome to the Entrant. The topic for today's discussion is Article 14, Right to Equality. This topic holds great importance when it comes to questions asked in competitive exams. Before delving into the subject matter, let us understand what right to equality and its applicability is. Introduction and applicability of Article 14. The concept of equality has been held basic to the rule of law and is regarded as the most fundamental postulate of republicanism. The Equality Clause, embodied in Article 14, does not speak of mere formal equality before the law, but embodies the concept of real and substantive equality, which strikes at the inequalities arising on account of vast social and economic differentiation and is thus consequently an essential ingredient of social and economic justice. Article 14 is applicable to all persons within the territory of India. The term persons has been used in the article and therefore means that it is not just limited to citizens of India but also extends to natural or artificial persons irrespective of whether they are citizens or aliens. Article 14 constitutes of two parts. First, equality before law, and second, equal protection of the laws. While equality before the law is a somewhat negative concept implying the absence of any special privilege in favor of individuals and the equal subject of all classes to the ordinary law, equal protection of the law is a more positive concept implying equality of treatment in equal circumstances. In the coming slides, we will look at these two terms in more details. Equality before law. The concept of equality does not mean absolute equality among human beings, which is physically not possible to achieve. It is a concept implying absence of any special privilege by reason of birth, creed, or the like in favor of any individual, and also the equal subject of all individuals and classes to the ordinary law of the land. The guarantee of equality before the law is an aspect of what Dicey calls the rule of law in England. It means that no man is above the law and every person, whatever be his rank or condition, is subject to the jurisdiction of the ordinary courts. Professor Dicey gave three meanings to the rule of law. First, absence of arbitrary power or supremacy of the law. Second, equality before the law. Third, constitution is the result of the ordinary law of the land. But in the Indian system, the third aspect of Dicey's rule of law does not apply, as the source of rights of individuals is the Constitution of India. Thus, the Constitution is the supreme law of the land, and all laws passed by the legislature must be consistent with the provisions of the Constitution. In the case of Rubinder Singh versus Union of India 1983, the court observed that the rule of law requires that no person shall be subjected to harsh, uncivilized or discriminatory treatment even when the object is the securing of the paramount exigencies of law and order. Thus, the rule of law embodied in Article 14 is the basic feature of the Indian Constitution and hence it cannot be destroyed even by an amendment of the Constitution under Article 368. Moving on, we will look at equal protection of laws. The guarantee of equal protection of laws is similar to the one embodied in the 14th Amendment to the American Constitution, which reads, "Nor shall any state deny to any person equal protection of laws." This has been interpreted to mean subjection to equal law, applying to all in the same circumstances. It only means that all persons similarly circumstanced shall be treated alike, both in privileges conferred and liabilities imposed by the laws. Equal law should be applied to all in the same situation, and that there should not be any discrimination between one person and another. Thus, the rule is that like should be treated alike and not that unlike should be treated alike. The word any person in Article 14 of the Constitution denotes that the guarantee of the equal protection of laws is available to any person, which includes any company or association or body of individuals. The protection of Article 14 extends to both citizens and non-citizens and to natural persons as well as legal persons. The equality before the law is guaranteed to all without regard to race, color, or nationality. Corporations being juristic persons are also entitled to the benefit of Article 14. This has been held in the case of National Legal Services Authority versus Union of India, where hijras and transgenders were entitled to legal protection. The Supreme Court has held in this case that Article 14 does not restrict the word persons and its application only to male or females, and hijras and transgender persons who are neither male nor female fall within the expression of persons. They are entitled to legal protection of laws in all spheres of state activity, including employment, healthcare, education, as well as equal civil citizenship rights as enjoyed by any other citizens of this country. Now we will look at the concept of class legislation. Article 14 prohibits class legislation. Class legislation means legislation differentiating between the same class of persons. It means that which makes improper discrimination by giving particular privileges to a class of persons randomly selected from a large number of persons, all of whom stand in the same relation to the privilege being granted. That there is no reasonable distinction between the person selected and the ones not selected, and that there is no justification to the inclusion of one and the exclusion of the other from such privilege. To illustrate this, in the case of Hiral P. Harsora versus Kusum Narottam Das Harsora, the Supreme Court struck down Section 2Q of the Domestic Violence Act 2005, which enabled the victim of the offence to file a complaint only against a male adult person and not against any female member of the household. The court held that the expression adult male person in Section 2Q be read as adult person. Moving on, the concept of reasonable classification and test of reasonable classification. Article 14 forbids class legislation. However, it does not forbid classification or differentiation which rests upon reasonable grounds of distinction. The principle of equality does not mean that every law must have universal application to all persons who are not by nature, attainment, or circumstances in the same position. The varying needs of different classes of persons require different treatment. In fact, identical treatment in unequal circumstances would amount to inequality. So, a reasonable classification is not only permitted but is necessary if society is to progress. Therefore, while Article 14 forbids class legislation, it does not forbid reasonable classification of persons, objects, and transactions by the legislature for the purpose of achieving specific ends. But this classification must not be arbitrary or artificial or evasive. It must always rest upon some real and substantial distinction bearing a just and reasonable relation to the object sought to be achieved by the legislature. In order to pass the test for permissible classification, two conditions have been laid down in State of West Bengal versus Anwar Ali Sarkar, 1952 Supreme Court. Namely, 1. The classification must be founded on an intelligible differentia which distinguishes persons or things that are grouped together from others left out of the group, and 2. The differentia must have a rational nexus with the object sought to be achieved by the statute in question. What is, however, necessary is that there must be a substantial basis for making the classification, and that there should be a nexus between the basis of classification and the object of the statute under consideration. In other words, there must be some rational nexus between the basis of classification and the object intended to be achieved. The expression intelligible differentia means difference capable of being understood. a factor that distinguishes or in different state or class from another which is capable of being understood. The Supreme Court, in landmark judgment of Menaka Gandhi versus Union of India, clearly ruled out the room for arbitrariness. Article 14 strikes at arbitrariness in state action and ensures the fairness and equality of treatment. The court further held that the principle of reasonableness, which logically as well as philosophically is an essential element of equality or non-arbitrariness, pervades Article 14 like a brooding omnipresence. This concept that is being stated in the case of Menaka Gandhi versus Union of India creates a new dimension of Article 14 which transcends classificatory principles. Here, Article 14 is no longer to be equated with the principle of classification. It is primarily a guarantee against arbitrariness in state action, and the doctrine of classification has been evolved only as a subsidiary rule for testing whether a particular state action is arbitrary or not. If a law is arbitrary or irrational, it would fall foul of Article 14. Moving on, the rule of equality is, however, not an absolute rule, and there are certain exceptions to it. First, equality before the law does not mean that the powers of private citizens are the same as the powers of public officials. For example, a police officer has the power to arrest, while as a general rule, no private person has this power. Second, the rule of law does not prevent certain classes of persons being subject to special rules. Thus, members of the armed forces are controlled by military law. Third, ministers and other executive bodies are given wide discretionary powers and by the statutes. A minister may be allowed by law to act as he thinks fit or if he is satisfied. This is done through delegated legislation. Fourthly, certain members of society are governed by special rules in their professions, that is, lawyers, doctors, nurses, etc. Such classes of people are treated differently from ordinary citizens. The Constitution itself contains provisions which under certain circumstances limit the effectiveness of Article 14. 1. Through the 42nd Amendment Act 1976, Article 31C was added. This states that the laws made by the state for implementing the directive principles contained in Clause B or Clause C of Article 39 cannot be challenged on the ground that they are violative of Article 14. Article 359 Clause 1 provides that the proclamation of emergency is in operation. The President may, by order, declare that the right to move any court for the enforcement of such rights conferred by Part 3, except for Article 20 and 21, shall remain suspended. Under Article 361, the President and the Governors are exempted from any criminal proceedings during the tenure of their office. And lastly, under international laws, foreign sovereigns and ambassadors enjoy full immunity from any judicial process. This is also available to enemy aliens for acts of war. With this, we come to an end.